Good evening, members, and welcome to our IDS webinar tonight. We do have a guest tonight, and he's going to be taking over the webinar here in a few minutes. But we did want to make a few announcements. One is I am very excited, and I'm sure Dr. Sheldon is as well, about our website changes coming up. We have had the same website since the IDS has begun, and the website mostly has just talked about different events that we have coming up and different things about us, but it hasn't really been an essential tool for what we can help you guys with and offer you guys. And so what we've done is all the webinars, teleseminars, documents, everything that we have done since 2014 when we began, we have had somebody help us create an amazing portal where you will now have access to all of those webinars, teleseminars, programs, videos, modules. Everything that we've done will be on this portal, easy to find, easily labeled, so that you can, whatever it is that you need help with or you're working on, you can go to the website and find it very easily. So you don't have to email us anymore and ask us where something is. It'll all be right there ready for you, and no matter when or where, you can always find it. So I'm very excited about that.
You can email us for other reasons. It's okay.
Sure. Questions. We'll take lots and lots of questions.
Right.
But I'm very excited that you will have everything you need that day, that time. So you don't have to wait for the webinar to come up. You don't have to wait for us to talk about that subject. Everything will be there ready to go.
Yeah, we're really excited. Daniel's been working really hard at it, and we've been working hard with a few other things. So
yes.
We'll see some things roll out. But here's who's rolling out right now. Michael Kahn has been a friend of mine for a long time. We won't talk about him.
Yeah, we don't. Yeah. And thanks for telling me I'm rolling out. Okay, I'll put on a pound or two, but let's not.
That was quite a party on Saturday night, you know.
Right, that's right.
So I've introduced Michael before. I've introduced him to you when we promoted this. Suffice it to say, Michael is a single practitioner who takes on the big boys and wins. And he has helped Danielle and me out. He's helped us out in varying regards, always very successfully. Not that we get into that much trouble. We don't. But, every once in a while you want to be able to avoid trouble. Michael has helped both of us avoid trouble. And we thought that would help you, because there are certain benefits that a smart lawyer can give you, and certain advice maybe you can give to another attorney in order to be able to help each of our members out.
But Lee, I thought you had me on. I didn't know you had a smart lawyer on. I don't want these people to, think there's somebody else's attorney.
They're turning you out already.
I guess so.
Yeah. So, Michael, thanks. Thanks for being with us tonight.
Sure.
Taking some time out of your personal life. We appreciate your being here because I appreciate you.
No problem.
So let's talk about it. Contracts is basic law. And yeah, you can go on TV and you can order legal Zoom, or you can do whatever you want and get a contract, and here it is. But maybe that's not good enough. And there's certain things you can do to help yourself.
That's true. And just by way of a little bit of background, I've been practicing law now 40 years, and I'm a Duke University graduate. So any of you UNC people out there, I'm really sorry about that. But back to the subject matter, I've represented and still do a number of different physicians, dentists, and a variety of different professionals. And so back to your point, yes, the idea of it's an interesting juxtaposition that you just made with LegalZoom, Lee, because you see, it's so easy that what you think you can do and save money by doing it is to go to LegalZoom. And I'm not putting down LegalZoom. There's a lot of good lawyers behind it. But what really a contract is all about is its personalization, meaning that every contract is really a specific situation and dealing with it. And so you're right. And one of the things that I found out over the years that I've been doing this is when you draft a good contract, two things happen, actually three things happen. One, you're drafting good, clear, and concise terms so that everybody is clearer about what exactly they're bargaining for in the contract. That's the first thing. The second thing is a good contract acts to dissuade litigation. And that's what every, I think, ethical lawyer is looking to do. And that's the way I try to practice my law is practicing law. You can make a very good living at it, and you don't have to more or less curry or engender litigation doing it. A good contract can dissuade a party from litigating. And then the third thing that happens is that if God forbid you get involved in litigation, a good contract can give you a clear edge over your opponent in litigation, which oddly enough acts for everyone's benefit because a clear edge means that you can limit attorney's fees. And that's the whole goal of good contractual provisions, limiting attorney's fees in the drafting of the contract. But if you get into litigation or dissuading litigation, you are limiting attorney's fees. Because once you enter that justice system in a lawsuit, well, let me put it this way. There's a French curse that they give to their enemies, and it says, and the French curse goes, may you be involved in a lawsuit and may you be right. And the reason is because the expense of litigation, as right as you think you are, and sometimes that being right engenders the wrong sort of feelings that ends up with you spending a lot of money to prove it in a system that is problematic at best. And so that's the whole point of why we're here.
Well, I know somebody, man. I know somebody in town. You don't know him, I don't think, but it was a person who every time he got into a little bit of trouble, a little bit of dispute, immediately went and sued. And he kept on losing his shirt, or maybe he didn't lose his shirt, but he lost a lot of money.
Sure.
And all of the things that he had to put on hold because he was concentrating on the lawsuit.
Right.
It was ridiculous. I mean, you could see it. And I think, can you blame the attorney? I suppose to some degree. Some attorney is going to give you advice, well, let's sue. And that has to do with ethics. We talk about ethics in this organization all the time. And part of it just has to do with emotions. I've got to win. They were wrong. I was right. And therefore, $20,000 later, he's
at least
still lost.
Right.
And so it can be a problem.
It sure is.
So, all right. So there's some things you can do. There's some things you can do to put into a contract, which maybe they sound complex, but they're probably simple things that you can do to. We do have things that we do. We use floss to prevent periodontal disease. You're doing some things in the contract to help prevent our ever getting to litigation. So what are some of those things?
Well, a couple of things, and some of the most basic contractual provisions can be used to dissuade litigation. And a lot of it depends on leverage. In other words, who has control of the transaction. But, basically, if you get into a contract where the other party really wants to do business with you, one of the ways to dissuade litigation is to have the venue and of any resulting litigation in your county, because that puts the burden on the other person to come to your county as averse to, let's say, going to their county or leaving it open. And so there is generally and always really a clause in the contract where you are going to specify, if God forbid there's litigation, where is that litigation going to occur? And you don't leave that wide open. If you can get it, it should be in your town, and that's a very important thing. So that's one thing you can do.
Okay. And we've experienced that ourselves, which it's a powerful piece. If somebody has to travel here to be able to,
have to be forced to that. Yeah. That's true.
Now, I've seen it in contracts, and I don't know how you feel about it, but there's this idea that, of course, you can go to court, but then written into a contract, it may talk about hiring an arbitrator or going to some kind of either binding arbitration, or maybe there's another kind of arbitration that you can go to that it almost short circuits the court, or it seems like it takes it away from from the court. Can you explain that and
Sure.
whether it's a good idea or not?
Well, there's a lot of misunderstandings and misinformation, Lee and Danielle, about those sorts of concepts. There's litigation, and then there's what's known as alternate dispute resolution. And that really gets into two different areas. One is arbitration, like you said, and the other one is what's known as mediation. Now, right off the bat, you're probably going to see in many contracts arbitration, and I absolutely do not favor arbitration. For 24 years, I was an arbitrator and with the American Arbitration Association. And the main reason I don't favor arbitration is that there's no real appeal from it. What I mean is, and this this surprised me when I ran into it. When you get an arbitrator, and it's true you can have non-binding arbitration, but that's never present in contracts, or very rarely. Yeah. Arbitration is always used in lieu of litigation. But here's the point. If there's litigation and you don't feel that the judge or jury serves you well, you can appeal it in a full plenary fashion. In arbitration, there's no real appeal. And when I first was trained to be an arbitrator, I found that incredible. And I looked into it as to why that was. And there's only very small grounds that you can appeal in arbitration, and they are limited to fraud if somebody's paying somebody off. Well, in other words, I asked this question once of my trainer, my arbitration. I said, you mean to tell me if the arbitrator totally blew the law that you can't appeal it? And he said, that's right, which shocked me. And the reason why is because you've entered a contract to arbitrate, and therefore you've really given up your litigation rights. So for everybody out there, no to arbitration. Okay, that's number one. Now, there's another alternative dispute resolution facet that I am in favor is, and I build it into all of my contracts because in at least in our county and in most counties, it's very successful, and that's mediation. Now, mediation is a non-binding resolution where the mediator acts as a neutral and actually shuttles between the two parties getting a resolution. Now, in our county, it's 80% successful. And what that means is it stops all the litigation. So in my contracts, what I always have is I require the parties to mediate before either one of them initiate litigation. It's a huge thing, okay, because, and also I got qualified as a mediator because I wanted to see, I only do very little mediation, but I wanted to see it, from the point of view of the mediator, besides being in literally hundreds of mediations itself, so we talked about a situation where you, let's say, were dissatisfied with your litigation where you can appeal. But if you mediate to a settlement, it's all done right there. There's no appeal. The legal fees stop. And as the mediators invariably say, you are controlling your destiny rather than letting a stranger, either 6 strangers in a jury or a judge, control. So the two things we've discussed so far are that in my contracts, I always put mediation as a precursor to any litigation. But and I also add that the mediation has to occur in my client's county, okay? Yeah. And then, but if mediation fails through impasse, or the parties are not able to select a mediator jointly, then when we have litigation clause, I always want the litigation to occur in my client's venue in their county. So that's the two things that we've discussed so far.
All right. So in mediation, you've got to hire an attorney to represent you. True. As a mediator. You're not going to do it yourself.
Right. Is that you're actually having an extra cost that is split between the parties. That mediator, him or herself. So you do have the lawyer representing one party, the lawyer representing another party, and you split the mediator's cost. Okay. And so there is an additional cost. But if you end that lawsuit right there, or that potential, you more than save it right there, because because litigation is an endless abyss. And therein lies the French curse, especially if you think you're right, you get invested, as you said, Lee, your ego's invested, being right. And what you think is a small lawsuit can go on to $100,000 like that, and then it dwarfs anything you're doing. And you also mentioned another point, which is important. Which, as business people, would you rather do? Spending your time productively doing your business,
Right.
or coming to me and paying me money?
Yeah.
I mean, it's an absurdity to enter into the legal system and expect to receive something that's meaningful unless you're absolutely forced to.
Okay, give me some stories.
Oh boy,
stories?
Yeah, there's many stories.
They illustrate the points that we're talking
They
about.
do.
Yeah.
And there's been times when through leverage, because my client's the other party on the other side really wanted to deal with my client, and so they gave me what I wanted, okay, in the document. And first of all, a lot of times I end up reviewing documents, and so there's been numerous times, not just one, not just 10, 50, 100 or more, where the other party wanting to deal with my client will sign the mediation clause in our county and will sign also the litigation clause in our county. And when situations have broken down and all of a sudden people who've really once gotten along, they threaten lawsuits. And then also the choice of a mediator comes in. And the powerful thing about having in this town is I know all the mediators, and I'm not saying that in a one-sided way. I'm saying all I ever look for my clients is what's fair. And so there's been numerous times when things start off in a wonderful way, and the people just, for whatever reason, start to devolve in some petty disputes, and one threatens a lawsuit, and I just raise my finger and I speak to the other person's lawyer and I say, first we mediate. And oh, by the way, if you check the sections of the contract, we're mediating here.
Yeah.
And then what has happened in numerous occasions, even before the mediation, because they might be traveling from out of state. Sometimes I've done that. When my one particular instance, my client was in New Jersey. He was dealing with New Jersey, and we put the venue, because he had the right to, in my county down here in Florida, where he was more willing to come down, and the other party was in California. And so automatically, in that particular instance, lo and behold, they settled even before they reached mediation rather than, and that happens a lot one way or another.
Yeah, so that is something of a, all right, well, that's a good example. Prevention, really.
Yeah.
Let's assume that you go through mediation. So let's assume you're in the 20% rather than the 80%.
Right.
So then it goes to a regular jury trial or something like that.
Right.
Okay, so you've got that option totally open.
Sure.
By doing that
exactly
rather than doing arbitration.
Right.
You've given up everything.
That's true. And another provision that I usually put in the contracts has to do with attorney's fees itself. The way I put it is that in a contractual provision that the prevailing party gets attorney's fees. And therefore, that is another disincentive for frivolous litigation. If somebody threatens you just because they may have more money or they think they just want to roust you and have no, but if they know that down the pike, that if it's a frivolous lawsuit, that they're going to have to not only pay something, but pay your attorney's fees, that ends up also to be a disincentive for litigation. So that's a third provision that I like to have in my contracts.
Right.
That is prevailing part, what's known as prevailing party attorney's fees. And that's not automatically the case. There's a misconception there. A lot of people think that, oh, you get your attorney's fees back automatically if you're right. No, and that is not true. In Florida, you only get them back. This is roughly the same in every state, some variety. And I practice in several different states. I'm not licensed in several different states, but I've litigated, and I think I had to think about that today some in something like 7 different states. And generally speaking, the only time that you can get attorney's fees back are 2 ways. One, if a statute says you can, which is hardly ever, or if the contract says you can. So if right in your contract it says prevailing party, so that's a third way to disincentivize frivolous litigation if you have a prevailing party attorney's fee.
Well, the times we write contracts like this and it says mediation, it says attorney's fees, and the other side says, heck no, we're not even going to sign that contract?
Well, there are some, but those are the kind of people that you don't want to sign it. And that's another point. And that is that the presence of these basic clauses in there also scares away people who are inherently no good, and that you would want not to sign your contracts because they're thinking, well, my machinations won't work, this. And so those are three very basic but powerful contractual tools to both disincentivize litigation and also, if God forbid you go down that road, to outflank your opponents.
Yeah, good. All right, so now I'm a company. I'm a Lee, but I'm also a company, Leon Sheldon DMDPA. All right, so let's assume that I'm signing a contract with a company like me rather than signing a contract with an individual.
Right.
What does that do to me, or how am I protected? Or maybe the other end, because I'm a company rather than being an individual, how am I protected that way?
Well, that's another good question. And the answer is, if you're signing a contract with a company, the good way to make it clear that you're serious is to get the individual behind the company to guarantee it and to sign on that contract.
So
too.
It's me, Leon Sheldon, DMDPA, and then it's Lee Sheldon.
Yeah, and now I won't ask that of my client, of course,
right,
but I'll ask that of the other side if you got some serious, let's say, doubts. And why? Because let's say you get a judgment against a company. We'll go try to collect it, okay? Or because you can have a principal of a company. But now, and that varies somewhat state to state, and I'll tell you what I mean by that. Florida is one of the last bastions of corporate limited liability. Everybody asks in Florida, lawyers, why do we need a corporation? And the answer is two reasons. One, for potential tax protection. And what I mean by that is that, and this I think counts throughout this country, if the IRS audits you and they find that basically that you owe a lot of money, and what they're going to first ask for is your minute book. And if your minute book, and I used to lecture for the FICPA for 18 years, and I used to kid my clients there, the CPAs, and I said, well, I know your clients are like mine, and anytime I get a corporate book, it's all completely filled out. And they all start laughing. Because if you have an empty corporation, the IRS can audit you and they can disregard that corporate entity, and they delight in doing so and look to your, as if it doesn't exist. So all your deductions, they're looking at you. Well, that's the same with the plaintiff. In other words, if you don't have your corporation organized, and I know this is a little bit apart from what we said, but it gets on another point that I think is important for all of the individuals tonight to know. And that is, if you have a company, you make sure that that company has a corporate book and that all the paperwork in that corporate book is filled out, the stocks are issued, and that you have a meeting at least once a year. Because here's a story for you. Okay, if a plaintiff sues you, and the first thing that his lawyers are going to want to see is your corporate minute book. And let's say that you're like a lot of the clients that I get coming in, and there's nothing in there. There's a doctrine known as, quote, piercing the corporate veil, end quote, that means their lawsuit is not only against the corporation, i.e. limited liability, but can come against your personal assets. Ouch. So I represent, and I, to this day, represent a New Jersey physician, genius, triple board certified gastroenterologist, absolute genius. And unfortunately, he was sued. Okay, he made a lot of money in different businesses, and he was sued, and the plaintiffs were dead set against him. And they asked his corporate book because they sued him personally, and his accountant couldn't find him. And luckily, I didn't start his corporations. Okay, so everybody was betting on the fact that, and so his accountant says they're here somewhere, and they were all rolling their eyes, and the plaintiffs were licking their chops to get at his personal assets. And after 2 years, the accountant came up with these books, and everybody then thought, nonsense, it's phony. Well, when we looked at these books, the accountant kept on saying, they are in my garage somewhere. And he had to be right, because these were so detailed in their annual minutes that the plaintiff just looked at me and just kind of walked away. And we saved that man millions of dollars by that one aspect. So it wasn't quite your question, but it goes to another thing of organizational corporate law, ladies and gentlemen. And that is, if you have a corporation out there, make sure it's correctly documented for both tax and limited liability purposes. So on the other, back to your question, is if I'm Lee Sheldon's company and I want a contract, I want not only the company to sign it, but I want the other side's principal to sign as a guarantor.
Okay. All right. How else do you want to keep us out of trouble?
Oh,
You want to talk about marital law?
Yeah, well, then that can go on and on and on. Remember, we have known each other for so many years,
It does always seem like there's somebody always ready to sue. And that's one thing I kind of feel like I have to keep my eyes open in the practice. And it's not only patients, it's, it could be staff, it could be anybody walking into the practice and asking for some water. It's always something. And I always feel like there's things that we need to do as a staff to protect the practice. And the only thing that I know of really is we have to have signage. We have to make sure that we are falling within the laws of what our part is for the people coming in or being on our property, and also with documentation. You've always said document everything said, everything exchanged, everything done, and make sure everything is in there. So we document text messages, emails, phone calls, everything that's said between you, the patient, everything. So, and it's saved us a few times. We have very large, thick charts.
We do, because if I'm working with a new patient,
right,
and I'm talking, the assistant is not sitting there. The assistant is at the keyboard typing everything
like a
that's said,
transcriptionist,
and everything that the patient has said.
Yeah,
that's excellent.
And it's helped us a few times. A few times we had to go back and say what was said during the new patient examination, and it's not in the medical history, it's not in the paperwork, but it's in there during the new patient examination.
And you're acting by doing that, Danielle, to again dissuade litigation, and we often tell our corporate clients, especially our professionals, our medical individuals, dental practices, to do that, because if they accuse you of something, and then all of a sudden you look back in your notes, you say, no, on January 23rd, you said blank,
yes.
And then people get afraid.
Yes.
You mentioned staff, and as you know, we're always big on executing staff agreements with either non-disclosure agreements or non-competition at different times. But I think that's important to keep people in line with what they're going to do when they leave the practice, or
I agree.
So there's a number of different internal documents that can also dissuade litigation between you and your staff.
Yeah.
And our staff documents have gotten us out of trouble. Not that we get ourselves in trouble, but we've had to defend ourselves quite a bit of time. And the staff files that we keep as well, same thing. I just document everything that's said and done, and good days and bad days. I document everything for all of our staff, because you never know.
It sounds like we're going through litigation all the time. We're not, and we're not getting into trouble all the time. But understand that as your practice grows, and as we do the things that we're doing here, your staff is going to grow. And as your staff grows, you can't just say, all right, I'm going to treat it the way I always did.
Yes.
Each new staff member becomes a liability.
Yes.
They become a big help to us, and don't get me wrong. But they are a liability, and it's these documents that we create in advance, and all the paperwork that we do to start this, and all of the notes that we take, whether it's with staff or with patients, all the documentation is if there is trouble, it's a little bit of trouble, and it's over because of the documentation.
That's right.
I've had times where a few times I've had to let go of a staff member because something happened, and then they would go and file for unemployment or such, and they would say, well, what did the staff member do? Well, if I didn't keep documentation, honestly, I would have to say, well, I know one time was this, and I can't remember in 5 years the good days and the bad days.
Sure.
And so when I go back in these files and I've submitted them to the attorneys at the time, they would go, wow, you have a lot of stuff in here, and you can find millions of reasons. Sometimes Eleanor says, why'd you wait so long? But at least, it's in there, and it does help us because I forget good days and bad days. We have how many staff members here? So I always look at it as protecting ourselves from getting to that point.
Sure.
Because when we get to that point, we're helpless. I don't know what to do.
And we've also had staff members who entered into self-correction. And so they wrote up what they were going to do. Well, if they correct themselves, that's great.
Right.
And if they don't correct themselves, they've already written in their handwriting what they're going to do when they don't do it.
That's right.
So, there are things that we do. And, if you want some examples of that, just email us and just let us know, because there are things that you can do within a practice to even not have to call Michael.
Yeah, that's it's a sad psychological fact. How would you like to go through life? When you really like your clients and they never want to see you again. I mean, but that's a good thing. Or they want to see you only in positive things. Let me kind of run with a couple of things that both of you said that we really haven't talked about, and really very rarely before. One of the powerful things of doing a practice the way I do, and it's a throwback in a way. There are not many sole practitioners who are generalists and others, but I've done a lot of things, and I guess that just means I'm old. Okay, but the bottom line is that that I like being a contractual lawyer and knowing what it's like in the court, because that enables me to write things into my contracts, just thinking about me in front of a judge or examining a witness. And why am I bringing that up here? One thing that both of you said is very important in dissuading litigation. I always have my clients journal everything, no matter what, for exactly what you said, Danielle. If you get up in front of a judge and somebody said, well, why did you fire this person? Well, the person was not a good employee and was endangering patients. Well, give me a specific. And you say, well, I remember one time, and then there was another time, and it's the vagaries will hurt you. But if you say, well, I have a list here, and on the 4th of June, I remember she did such and such, or he did such and such, and then 2 weeks later, after being warned, on July 6th, they did, and that really seals the deal. Judges are impressed by that because they know that you're just not, making it up. And it's a very sophisticated way to do it. So I applaud both of you and any of you all out there that take the time. It's not that we're in litigation all the time. Everything we've talked about tonight so far is going to keep you from getting into litigation. And that's just being protective in an ever increasing and ever more litigious world. And that's just too bad for everybody.
That's the way it is.
Yep.
That's right.
Anything else that I think it was good finish?
Yeah, I don't think, you could, we might have a reprise, next time we could cover something else, but no, I think this is really a good basics for what you want to put in a contract, and which are, to summarize, one, you want mediation, not arbitration. Two, you want all of the clauses about venue and location in your county. And three, you want prevailing party attorney's fees. The fourth thing we said is if you have a corporation or a company, you make sure the documents are clear to prevent against tax attack by the IRS and plaintiffs attacking the lawsuit. And last, you document everything. And I think that's what we've talked about.
Good. And I want to cover one more thing.
Sure.
Because you and I just talked about it before the show.
Okay.
And that is hiring the best attorney.
Oh,
Example. All right. So we have something that comes up. I bring it to you.
Sure.
You say, yeah, I can look at it. And then I say, well, my malpractice company is recommending this attorney who's certified in healthcare, and he charges $175 an hour. And you tell me what?
Well, I tell you a lot of different things. Okay. And that's a really good question. And here's the power of that. For example, I'm not a healthcare lawyer, but over a period of years, I've found a person that I consider to be the best in the state of Florida. And he charges a lot of money, but we only need to use him on situational bases. And that's the blend. Now, he doesn't try cases, so I would be the courtroom lawyer if I needed to use him. But you're really hitting on something big that is throughout my practice. One of the things that I don't think that good lawyers are given a lot of credit for is to know what they don't know. And what that means is that over a period of years, I've just, of course,
We see that in dentistry too, by the way.
oh, I believe. Trust me, I know what you're saying there, Lee. I know exactly what you're saying. And if there's some specialty or area that you don't do primarily, and that there's somebody who does, to point your client in that direction, that is to me, and it's an unthanked credit to when you can find a lawyer that will do that. So that's exactly right.
It's true. And so, and essentially what we've done is to use this particular attorney who charges $500 an hour
Right.
in order to not have to go through the stuff that we don't want to go through.
Exactly.
And so, yes, essentially, I'm accepting the 175. I'm paying him the 500.
Right.
And okay, so a little bit of money is coming out of my pocket, but very little time is coming out of it because he's so good and
Right.
he knows how to prevent things from going any further.
Absolutely.
So, it's important. And I think the automatic thing that we would do is, all right, I've got my malpractice carrier and they're assigning me to this certified healthcare attorney.
Right.
That's all I need to do.
Right.
And in fact, and that's what I would have thought until I talked to you.
Exactly.
Yeah.
And I think that that's, again, overall what you need from your attorney is the trust and the bond that you do, just like you would need from your oral surgeon, your dentist, your periodontist, that you need to find somebody that you can trust to both do what he or she can do, and then when they need somebody that's outside their generalized practice or their practice, to call upon that person, but limit it so you don't have to pay a lot of money. I mean, the goal of all of good practice of law is to limit attorney's fees, and it's a good enough living. You don't have to do anything stupid and greedy. And so that's what I love about the practice of law. For the 40 years that I've done it, you're helping people when you do it right. And I would like to think that I do it right.
Yes, you do.
Thank you.
You've done it for us.
Thank you. That's very kind.
Michael Kahn, just a great resource, just a great friend. So thanks for being with us.
My pleasure. Anytime.
Good.
Thank you.
Okay.
And we'll see you again. I think our next one is in September.
Sounds so far away.
Yeah, it is.
It's coming.
I know.
we will let you know. By the way, check out AP Connect. We've got a good interview coming up next week with Howard Chaslin. I've sent it out to you. I'll send out the promo to you again. We've got something like 106 people signed up to talk about root reshaping and how to do that from the prosthodontist perspective and how the prosthodontist and the periodontist work together. This is for you. This is for your team. And I'm talking about the team of doctors that you work with, the restorative dentists. And Howard is just top notch, and he lectures all over the country.
I may want to audit that, Lee.
Yeah. Good. I'll send you the link. Thanks for joining us tonight. We'll see you in a couple weeks.
Thank you. Good night.
We hope you enjoyed this video. If you have any questions, please email us. The IDS is here to help every dental specialty practice do better. I'm Dr. Lee Sheldon. See you on the next video.